Today's case looks simple on paper. A routine Michigan driver's license charge. But what unfolds in this courtroom turns into one of the wildest legal spirals we've covered. Don Lee walks and expects to plead out a misdemeanor, and instead triggers a full-blown judicial meltdown over a missing case, a botched warrant, and a prosecutor's office that somehow remanded him into custody without a single confirmed charge. And when the judge realizes this, she goes nuclear. This is a sovereign citizen shouting, "I do not consent." But the chaos, the confusion, the system breakdown, it feels exactly like one. And trust me, the judge's final explosion is one for the books. Let's get into it.
Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right. Please state your name for the record, sir.
Don Lee.
All right. Hey, where are we on this case?
Thank you, Your Honor. This is a driver's license case, and I have discussed this with Mr. Lee. He will be accepting the offer extended to plead to MCL 257.326.
So, Your Honor, I'd move to add count 2 of MCL 257.326, allowing an ineligible person to drive. You accept that guilty plea to add count 2. I move to dismiss count 1.
Raise your hand. Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Don Lee.
This court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding all that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
On the date of February 10th, 2024, Michigan Road near Moon Road in Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court
Sir.
will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence?
Just very briefly, Your Honor. Mr. Lee is asking that the court consider sentencing him to time served. I do acknowledge he wasn't arraigned on this case until September 19th and only has 9 days credit, albeit he was not being held on this case. Outside of that, I just leave it in the court's discretion.
Anything you want to say, Mr. Lee?
And I just wanted to get this over with and keep him going.
You come back on the other thing tomorrow. Is it tomorrow?
He's up on the 8th.
On the 8th.
For exam, Your Honor.
Just trying to recall, when I put you into custody, did we set an exam? Is that what
Yes.
we did?
Exam is on the 8th.
Before me?
No, it's before Judge Burke.
Okay. All right, I'll take a look at that because all right.
I think I have the file out, Your Honor. Did the court have a question I could help with?
Well, I put him into custody, but I know I told him I was going to take a look at that on the remand into custody on it because it came as a result of a police report regarding something else happening.
Yes, it was because there is a new case that is coming down the pipe, to which Ms. Blanche said that the warrant was going to be authorized that day, I believe. Mr. Lee advises, and I don't see anything to contradict that, he hasn't been arraigned on that new charge yet, however, but the 2 ones that he was in front of Your Honor for last week for PCC are set for exam, both cases in front of Judge Burke on October 8th. He's represented by Sam Bernstein in one and the public defenders in the other.
Okay, so my question becomes all right, that's right. That refreshes my memory. Where's that other case? Because the thing, I'm not asking.
Okay.
You don't know.
I know I ain't been arraigned on it.
No, I know, but I'm trying because
So, Your Honor.
I don't know. Did I change his bond on? I did change his bond on that. He was supposed to then be arraigned on the other case, but that case was supposed to get. There was supposed to be a timing on that case to get down. So I remanded him. He was going to be held on these cases, on the ones that are set for exam. And then that other case was going to come down expected that he might be in on that case. But if that case hasn't come down, I'm not going to be very happy right now.
Yes, to my understanding, Your Honor, he has not been arraigned on that new case, but the two cases that are already set for exam in front of Judge Burke, currently his bond is $15,000 on each of those cases.
Correct. I get that. What?
You raised it was a PI bond and you raised it up.
I put it up because of the representation of these other cases, but those other cases were supposed. What's the status of that other case?
Your Honor, Ashley Lottie, for the people on behalf of talk about these other matters. So if I'm reading this correctly, other cases was a resisting and obstructing case that was supposed to be coming down. Is that, Ms. Page, is that correct?
I don't think that was, it was involving a car accident and some other stuff.
I don't know the exact charges that were to be authorized, but I know the incident date was before the ones that are currently set for exam.
Right.
That being said, I
know.
Yeah.
Listen, where is that case? Because my problem here is that, and Mr. Lee is certainly not always the most cooperative person in the world, and he knows that. But he got remanded because his other case was coming down.
Correct.
And so I'm trying to, and I think there was a representation that it had been signed off or it was someplace, and the expectation was that case was going to get sworn out. While in custody, he'd be arraigned. And then there would be, based upon the facts of that case, a bond set that was likely or may have, I won't say, I can't say for sure, may have kept him in custody, which is why I did what I did.
That was my understanding, Your Honor.
I just need a little bit more information.
Go, look.
So I want to understand, Mr. Lee was last before the court for PCCs. The court is saying on the 26th or the 18th.
I think it was a week ago, wasn't it? I think it was.
The 20.
I think it was the 26th. He was before me.
I have some help helping right now. So the new case, which does appear to be related to fleeing and eluding charges, dated date of incident 8/29/9/20 to 9/2. It appears that case was authorized, signed by my office on 9/26. And I don't see.
That's what was indicated to the court on the record, that it was signed off on 9/26. But then there was a representation that it was going to get sworn to. It was signed off by your office. I think that's what was represented to me.
People, this is where the whole situation flips upside down. The judge is desperately trying to reconstruct the timeline. When Lee was taken into custody, why his bond changed, what new case was supposedly coming down the pipe, and the more she digs, the worse it gets. This is classic sovereign-style chaos without the sovereign talk. Nobody knows where the charges went, who signed what, or whether anything legally exists at all. And here's the kicker. They remanded this man based on an expected case that never actually materialized. Twice someone tried to swear it out, and twice a magistrate said no probable cause. In real legal terms, that means the entire foundation for holding him was smoke. No magic UCC numbers. No I'm traveling nonsense. Just a system tripping over itself. Chat, how does someone lose track of an entire criminal case?
Get sworn to so that Mr. Lee could be arraigned on it.
My understanding is that Magistrate Fink signed that case on September 30th. It is likely.
Well, then why hasn't he been arraigned?
I'm not sure, Your Honor. It may be in a stack of things that are waiting to be entered. That's been happening.
Oh,
I don't.
no, that will not happen. Miss.
Can you tell me what the jurisdiction is?
Yes.
It's not.
It's
not
Ypsilanti City. It's Ypsilanti City.
It's a city case?
No, I showed us
It's a
14B.
sheriff's office. It's a sheriff's office arrest that occurred in Ypsilanti City.
I show it with the 14B.
Okay, so it's on the line. It said the swear out was on the 30th. Yeah.
I have a police officer.
Oh, really?
Yes, that helps.
So, whoa. Is that what the log notes indicate?
Yes,
So there are no charges?
correct. It says court does not find probable cause.
Okay.
Okay.
Go.
Just hold. That's what it says?
Yes.
So there is no case?
Can I confirm the police report number for that?
Mr. Lee, that's what we're gonna do. I'm gonna have them take you back
Okay.
and we'll
All right.
try to figure everything out, have you brought back out, and I'll do what I gotta do.
Okay. Thank
All
you.
right?
Thank you, Your Honor.
Thank you.
Assistant Public Defender Natalie Pate, with and on behalf of Mr. Lee, who stands to my right.
I still have to sentence him on the driving well or the operating well. So we've taken a look at it. That complaint that I put Mr. in custody on there was no probable cause found. And so that was not, done. And I'm going to say this. They knew the reason. Mr. Lee understood what I was doing and putting me in custody. The prosecutor's office, I think, given the representation made to this court, was under an obligation to contact this court immediately upon notification that those charges were not brought, knowing that affected Mr. Lee's liberty. And I'm not happy that I wasn't contacted at all. Anything you want to say before I sentence him on his misdemeanor?
Nothing further, Your Honor. I would just reiterate his request be sentenced to time served on that misdemeanor.
Fines and costs of $250. Those fines and costs are waived in their entirety. 90 days suspended on that case. With reference to his felony matters, those will continue to preliminary examination on October 8th before Judge Burke. Bond on those cases, both will be set at personal recovery.
Can you look into those previous conditions that were in fact with the
The conditions will remain. They never left.
Thank you.
It's just they took his liberty on something that didn't get authorized. You're going to be free to go, Mr. Lee.
I'm going home today.
You're going to be let out, sir.
Thank you.
Thank you very much, Your Honor.
Court's going to stand in recess.
All rise. Thank you, Your Honor.
You're welcome.
All rise. The 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Jay said to preside.
Has the state prosecutor left?
I think so.
She needs to get back in here because I'm going back on the record on Mr. Lee. I don't know who else has that case. You may be seated, folks. Yes. At 1 o'clock?
Yeah, she has
I want her here because I need a message gotten to that office right away. Court is recalling the cases of the people versus Don Lee, both his felonies and his misdemeanor cases.
Good morning again, Your Honor. Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate, on behalf of Mr. Lee.
I'm going to waive Mr. Lee's appearance because they took him down so he could be processed out immediately. But I want to make a record clear and know, and I realize, Ms. Lundy, you were not the one involved, but I am more than livid right now because this case, we went back and checked our records. Mr. Lee was taken into custody on the people's representation regarding the previous case. I took him into custody at 11:43 a.m. on June 26th. After having him wait here in court, I took him into custody on that date, and it's important, at 11:43 a.m. on the 26th. There was an attempt to swear out that case that was done before Magistrate Fink less than an hour later at 12:31 p.m., where the magistrate did not find probable cause. This court was not informed. Mr. Lee was in custody. It was another attempt made to swear out that complaint on the 30th. Again, no probable cause. It is inexcusable that the prosecutor on their representations had this court act that deprived Mr. Lee of his liberty for 7 days. Inexcusable. So, Ms. Lundy, again, while you are not the person that was involved in this, but has done, I will expect a call from Ms. Burton Harris regarding this matter.
Yes, Your Honor.
Today.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Squad, let's break down what just happened because this courtroom went from routine to explosive in record time. Don Lee came in to plead guilty to allowing an ineligible driver behind the wheel, a misdemeanor that usually ends with fines or short suspension. But everything derailed the moment the court revisited why he'd been remanded in the first place. They expected a new felony case to arrive, swearing it out not once but twice. And both times, a magistrate ruled there was no probable cause. The prosecutor's office never notified the judge, never corrected the record, and never acknowledged that Lee was sitting in custody for a week on a case that did not legally exist. So, the judge snapped professionally but unmistakably furious, ordering immediate release, waiving fines, suspending the sentence, and demanding accountability from the prosecutor's office. The takeaway: you don't need sovereign citizen script lines to cause courtroom chaos. Sometimes the system melts down all on its own, and when it does, a judge will shut it down harder than any Admiralty flag argument ever could. If you want more breakdowns of courtroom disasters, sovereign or otherwise, hit that like button, subscribe, and turn on the bell so you don't miss the next meltdown. Down.